So if you do anything a little bit more custom to your contract, you're adding in language, you're changing language, I always highly suggest that you review it with an attorney in your state to ensure that it's consistent with your state laws. Because the minute you start changing things, you could mess up cross-references. You could also end up having what's called competing language, where you're adding something into one clause and then you're not realizing that it's somewhat similar, but maybe different in another clause. And then you've got competing language, and contract interpretation and ambiguity comes into play.
Hey there, I'm Paige Griffith, your host and an attorney for small business owners. I help online businesses and creatives get legally legit in no time. This podcast is all about the legal and the Paige behind it. I'll break down and simplify legal talk while providing practical business guidance every step of the way. And after over a decade in the entrepreneur space and becoming a mother, I'll also be sprinkling in tips for running a business and giving you a glimpse behind the scenes of what life's really like. As a gentle reminder and disclaimer, I am an attorney, but I am not your attorney. So be sure to seek legal counsel for personalized advice. Welcome to the Legal Paige Podcast.
So in today's episode, I am going to go through a wedding photography contract, specifically the Legal Paige's wedding photography contract. I'm going to go clause by clause and let you know basically exactly the layout of our template contracts, what I suggest that you have in your photography contract, and nuances that we've made along the way. So if you don't know this already, the Legal Paige contracts come with all future updates. And this is our bestseller. So this contract gets updated all the time. Myself and my legal team keep our hands in the industry. We have people that ask questions in our emails and in our Facebook group and in DMs, and client situations come up and big industry shifts happen. And we make sure that we are keeping you up to date. We'll make very slight changes to certain clauses, or we will overhaul certain clauses, or we will add in certain clauses. So this episode is one you do not want to miss if you are a wedding photographer, if you're an elopement photographer, if you are a destination wedding photographer. I think it will also be very, very beneficial if you are truly any type of photographer, because a lot of these clauses will also go in your photography contract as well, just for a basic session. Of course, what I will be discussing today is a lot more tailored to weddings and events, but a lot of the clauses are very similar across the board in each and every photography contract. So let's get into it. I've really been thinking about how I wanted to go about this episode, and I've decided no outline. I'm going to shoot from the hip here, because I want to give you my real candid take as a lawyer in the photography industry, in the small business service industry. I used to run a wedding photography business. I know so much about what needs to be in a wedding photography contract. So instead of giving you a huge spiel on, hey, this is, some big story that happened, and this is why it's important to make sure that you're legally protected and have a wedding photography contract, I'm just going to cut to the chase here, because I think we have all heard of horror stories with clients, and I don't want that to happen to you. I don't want you to be a sitting duck waiting for something like that to strike your business. Instead, get a super robust photography contract written by an attorney, and even better, written by someone who is an expert in the photography industry. So here's what we're going to do. I'm literally just going to go through, not line by line, I'm going to tell you the actual verbiage in our template contracts, but I'm going to give you my perspective on each clause and what your photography contract should include. If you have an existing photography contract, I want you to get it out as you're listening to this episode and kind of use what I am saying as more of a checklist. Like, hey, you need to have these clauses in your contract. And then you can check off, yes, I have that one in my existing contract. And by the end of this episode, if you're missing a few, you can get those a la carte at thelegalpage.com. Or if you're like, you know what, it's time for me to upgrade and get a more robust contract, you can also just get our full length contract template that is done for you. You won't have to add any clauses in. Bing, bang, boom. It is a done for you, simple, easy button to press. So first and foremost, let's just talk generally about what our contract templates look like. When you open them up in Google Docs or Microsoft Word, you're going to see red information at the top. That is more of like my note to you as an attorney. There's a note from the legal page. It explains when the template was last updated, so you know if you are getting the most recent one. And it also explains kind of how the contract works. So we have bracketed yellow highlighted information throughout, and that means that you need to fill out those portions with your specific personal and or business information. And then, of course, I want you to always take out brackets in your contract, especially with template contracts. I see this all the time. I've actually had people send me their legal page contracts if they were, say, a contractor for TLP, and I've noticed brackets still in contracts. So they're really easy to miss, but just make sure that you do that with any type of template agreement that you're getting online. And then just know that it's a template contract, right? So if you do anything a little bit more custom to your contract, you're adding in language, you're changing language, I always highly suggest that you review it with an attorney in your state to ensure that it's consistent with your state laws. Because the minute you start changing things, you could mess up cross-references. You could also end up having what's called competing language, where you're adding something into one clause and then you're not realizing that it's somewhat similar but maybe different in another clause, and then you've got competing language, and contract interpretation and ambiguity comes into play. So yeah, just know that, of course, you can always modify your own contracts, especially templates that you get online from an attorney like the legal page. But just know the more heavily you edit something, the more I want you to kind of have your eyebrows raised and have like an orange or red flag pop up where you're like, I might need to just triple check this with an attorney in my state to make sure it is good to go with the changes that I've added. So with that being said, let's go through the contract, shall we? Your wedding photography contract at the very top needs to say wedding photography agreement. And then you will put below that your business name. And so here you want to say something along the lines of, Jane Snow Photography if you're a sole proprietorship, or Jane Snow Photography LLC if you're an LLC. If you're incorporated, you put Inc., so on and so forth. And then the beginning paragraph is always an introductory paragraph to introduce the parties, who the agreement is between, the purpose of the agreement, and then it explains when the effective date is. So in all legal page contracts, I always make sure that if it is a photography agreement for a large event and you are servicing 2 clients, you want 2 clients to sign your contract, client 1 and client 2, and then they're going to be outlined as such in this very first paragraph. And then client 1 and client 2 will sign your contract at the bottom. Never sign your contracts before they are sent to your clients. Make sure they sign them first, because if there's any changes that need to be had, then you can make those prior to you signing. That was just a little side tip there. Always sign your contracts after your clients do. So you're going to say at the beginning that the agreement is between, client full name number 1, client full name number 2. And then we always designate them as clients with a capital C throughout the remainder of the contract. And then we do the same for, the agreement is between client 1, client 2, and your business name. Never, ever put your first and last name here if you are a limited liability company or incorporated in any way, because you want the agreement to be between your company and the clients. Yes, you are probably the sole owner of your company, but never put your first and last name in a business contract. Always have your LLC be the party to the contract. And then we designate photography contracts. Your business name will then be photographer with a capital P throughout the remainder of the contract as well. And then we always have something, and you'll see this in similar contracts, where it'll have another parenthetical that says something along the lines of, collectively, this will be called the parties with a capital P throughout the contract, or in the singular party with just a Y. And then it explains, what is the purpose of the contract, that the clients are hiring the photographer for wedding photography services. And then we always state that the agreement shall become effective upon the date of all parties' signatures below. Next up, and this is just the way that I really like to write contracts. I actually like that first paragraph to be first before then you lay out kind of what would be typical for you to see at the very, very beginning of a contract. I like it to be one full agreement. So you have the introductory paragraph, and then you're listing out who the parties are. So the photographer, the clients, their names, email, address, phone number. Then you're kind of listing out the photography package that they chose. So package price, hours of coverage, is a second shooter included, additional travel fees, delivery of online gallery. This is really an itemized list for them to see and like a snapshot at the beginning of the wedding photography contract. And it'll also explain payment. So total amount of wedding photography services and the package price, the retainer amount that's due at the signing of this agreement, when the final payment is due, or if there are installment payments, you need to list out each and every payment and when that is due by. That will coordinate with section 1, which is the fee and retainers clause. We'll get to that in a second. And then finally, in this itemized list, I would also put kind of the wedding event date, the ceremony location, and the reception location if it is different, because that coordinates with the travel fee clause. So all of that is kind of the beginning of your wedding photography agreement. This is very standard across the board. You're going to see very similar things if you were to get your contract elsewhere. I just really like outlining it this way because I think it's really crystal clear for clients to understand, have that itemized, yes, 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 this is what I'm agreeing to, and it coincides with everything else that is in the agreement that they will see from there on out. Then I always put the terms and conditions. So that's usually a bold heading. And then we always number our clauses, bold them, and underline them. Yeah, if you haven't heard me talk about that before, the reason that I do this is because you want to easily point out certain clauses to clients. You don't want to hide the ball. If you don't have numbered clauses in your contract, it's going to be extremely confusing for your clients to look through, to go back and look at something in your contract if you were to point them to that. If they were reading a certain clause and it says section 17, but then you didn't number the clauses as such, then they're confused at what number is 17, and you're putting it on them to actually go through each and every clause and count them. Just don't do that. So always make sure that you're numbering, bold, and underline. I really like every contract to have as conspicuous as language as possible. Now, these are something special that you're going to see in our photography contracts. Our fees and retainer clauses, usually in almost every single photography contract that is related to a wedding or event, is going to have 2 different options in them. The reason we do this is because I don't want you to have to guess if you are doing a non-refundable reservation retainer and then just one additional payment. That's one option. And then say your clients want installment payments, maybe 3, 4, or 5 installment payments after they pay the non-refundable reservation retainer. We have both options listed out for you, so you get to choose, and then you delete the clause that you don't choose. So this is a really great solution for any photographer who would purchase or open our wedding photography contract or just buy a fee and retainer clause, because they're going to see all of these options here, and you can choose depending on your business practices. A couple of things that I want to point out in a fee and retainer clause: always, I suggest call it a retainer and not a deposit. You will see that wording throughout every single contract that we create here at the legal page. And that retainer amount should be set. It should be basically a set amount that all clients pay to book a specific day of the week on your calendar. So you're going to want to choose a price for kind of prime days of the week, Saturdays, Sundays, maybe even Fridays, and then non-prime days of the week. So maybe a Sunday through Friday, or, a Monday through Thursday type of situation, depending on your business. I know elopement photographers, like, every day is really a prime day. So disregard here, just whatever is kind of the average price that a client would need to pay as a retainer so that it is the same across the board. I always suggest this versus a percentage-based retainer, but those are kind of coming back into style a little bit now. And so if you want to do a percentage-based retainer, there's nothing legally, technically wrong with that. I just know that you're giving your clients an argument that someone else could be paying less of a retainer than them to book a very similar date on their calendar, and maybe they booked a 12-hour package instead of an 8-hour package, and that shouldn't matter. If you are still booking X date out on your calendar, it should be the same retainer across the board, and then they would just pay an increased fee either as the future payment or within all of the installment payments. So that's the first portion of a fee and retainer clause, that the clients are reserving the time and date of your photography services by signing this agreement and then paying you the non-refundable reservation fee equal to X. And then it lists out kind of what the installment payments are or what the final payment is and when those are due. Usually you always want a final payment to be due around 30 days prior to the wedding or event date. And then, of course, if you do things a bit differently in your business, you can always change that. If you want it 60 days, if you want it 14 days, that's up to you. Those are yellow brackets that you will see in our photography contracts. These are just merely suggestions that I give based on my experience in the industry, but you can always change it to what you do and what you're comfortable with. Then the rest of the fee clause really explains kind of late fees. It goes into if clients fail to remit payment as specified, kind of what happens with termination of the agreement and liquidated damages. That's important language to have in a fee clause. And then finally, we have no downgrades language in our wedding photography contracts. I think that's important because you've turned down other clients for this client to book this package with you. They can upgrade at any time, but they shouldn't be able to downgrade at any time. And if your clients ask to downgrade, you can then point them to this clause, and instead you could maybe swap things out for, some other services that you could offer them so that still the amount that they are paying you is the same no matter what. Moving on, a coverage clause. This is going to go over kind of the number of hours of coverage that they have booked with you. And then, of course, if you go over those hours, what is your rate per hour? This can be agreed to by all parties either before the event date, like they want to upgrade the package. They don't want 6 hours or 8 hours anymore. They want 10 or 12, say, for example. Or sometimes it's really in the moment where you are there, you've been there for 8 hours. Maybe you kind of over deliver a little bit and you've been there for 8.5 hours. And then you tell your clients, it's time for you to leave. And they say, can you please stay an extra hour or two? Your response is, yes, I would be happy to if you are happy to do so. And my rate is X for each hour. And you guys can agree to that verbally. And then the next day or that evening, I would definitely send an email to your clients and just reiterate, get it in writing, what happened, the extra hours of coverage, point to this clause. Here is, the fee, and send them an invoice, because you will never, ever be delivering any images or products to your clients and release those to your clients until they have paid for additional hours of coverage. The next two clauses I like to have as separate clauses because they're really separate instances. So we call them cancellation by clients and rescheduling by clients. This is clause 3 and 4. And these are voluntary cancellations by your clients. So if they want to cancel at any time, kind of more than X amount of days before the wedding date, and that needs to coincide with your fee clause at the top, which explains the final date that they will be paying. So that final payment's due date needs to align with the notification amount of days for them to cancel the agreement and not be responsible for any amount due. And then it kind of just explains like how notification occurs, and you need to get receipt of notification. And then finally, one of the biggest things that always comes up in the wedding industry is contracts that say if the clients cancel within, say, 30 days of the wedding date or 14 days of the wedding date, the clients are required to pay the full balance due. Or if they've already paid their full balance and then they cancel and they ask for a refund, do you have to legally give them a refund? The legal answer is no. No matter what Facebook groups are telling you, that is not true. And legally speaking, you have a massive opportunity cost that you could argue in court all day long, especially if you're keeping documentation of other people inquiring about those dates on your calendar whereby you have said no to those clients. Also, weddings and events in particular are booked so far out in advance that for you to be able to mitigate damages and get an entirely new wedding for that date is virtually impossible within a month or less. So I think you can keep that language in your contract. And if you ever have an issue with a client, you can just message me and my law firm would be happy to help you. But one other thing that I wanted to offer as an alternative here is you can add in a cancellation fee instead. So you could change that to, clients would be required to pay a cancellation fee of X. And then kind of depending on the state you're in and case law and things that a judge or, an arbiter would look at, is that a cancellation fee may be easier to enforce than keeping the full balance. And say you just want to kind of align that with your final payment. So say the final payment due 30 days out is $1,500. Maybe your cancellation fee is $750 or $1,000. That's pretty reasonable. And every day of the week, you're going to be able to keep a cancellation fee. And so if they cancel and say they've paid the full amount, then you would only be refunding like $500 versus the full $1,500. Hopefully you're catching my drift here. So then in section 4, we have rescheduling by clients. And this is all about transferring of a non-refundable retainer. If you don't allow clients to reschedule, we have 2 options in this clause. That they would forfeit the retainer and all of their payments made as liquidated damages, and that they would have to book you as a photographer under a new contract, and it would be subject to your new pricing at that time. Or what a lot of photographers do is the same kind of notification timeline as the cancellation one. So it's not a full-blown cancellation and they're terminating and never want to work with you again. And then you're trying to figure out what to do with, fees paid and non-refundable retainer payments. But a rescheduling would just shift that to a new date. And they still need to notify you, say within 30 days of the wedding date, but they could then keep all of their fees paid on as credit and be applied kind of only to wedding coverage within a certain period of time of the original wedding date. I like to say a year is kind of a good starting point. I think some people make it just 6 months, but a lot of times if they're rescheduling, maybe they have something going on that year and they need to push it to the next year. So this is also kind of a safe haven for your clients to really understand, okay, I can cancel and I can reschedule on my own volition, but I have rights and responsibilities under this contract, and it makes them feel way more comfortable signing when you have this type of language in your contract. The last thing I will say here is that those 4 clauses are probably the most important clauses in your photography contract. Yes, there's so many other clauses that are very, very important, but I like to put all of the most important clauses that a client is actually going to read, that they're actually going to look at the top of a contract. Because when you're sending contracts online, they're going to look at those clauses first. They're going to care about a fee and retainer clause. They're going to care about extra hours of coverage because that's what they're cued in on when they're booking a wedding photographer. And then they want to know if they could get an out here of the contract with a cancellation or rescheduling situation. So just always put those near the top of your contract. If you have another existing contract and you're listening to this, rearrange your contract is what I would suggest you do. And I do that all the time when I'm reviewing contracts for people. Is the first thing is I always try to organize, if this is sent online, clients are going to look at the beginning portion first, then they're going to scroll a little more feverishly to the bottom, and then they'll sign on the bottom dotted line. So the next clauses are kind of more middle of your contract clauses, very business specific clauses, kind of your policies on XYZ. The first is an exclusive photographer and kind of a videography clause. So you want to be the only professional photographer at the event, just so there is no confusion as to who took what photos. And then also, if a videographer is there, you probably want to explain kind of how you will work with the videographer, obstruction or intrusion situations. And then also that, potentially they shouldn't be taking still images or posting any still images until a certain time period after the wedding. And then that is on the clients to convey to the videography team, because of course you're not contracting with the videography team. But I would just hold your clients to that. It's important. They're working with multiple vendors. And this is also really important for wedding planners to know, because if they see this type of clause, they will make sure to also coordinate with all vendors involved. Next up is an image processing, retouching, and edits clause. Obviously, editing is a key part of your process and really final product. So this type of clause will help you define the extent of image processing, retouching, and edits that you offer so that your clients are really, really clear from the beginning what they can expect from their final gallery. This is a clause that has become a bit more nuanced here in the past few weeks. We have added very, very slight minimal wording changes to this, just so that your clients could never come back and ask you for an exorbitant amount of edits. I don't even know if that's a word. I don't know if I pronounced it right. Absorbent? It's fine. Moving on. So first off, the very, very beginning sentence needs to explain that you're only delivering edited JPEG images and you are not sending raw files to your clients under any circumstance. If you do feel like that you will potentially have the option to give them raw files, then you could change something in, this clause to that you will only send original raw files to the clients if all parties agree to do so, like in another raw file purchase agreement, and additional payment is received. But I suggest, my biggest suggestion here for the wedding industry and photography industry as a whole, is that you have a base foundation in your photography contract that says you will not send original raw files to your clients under any circumstance. Then, if you choose to do so later on, you can sign another agreement, but I wouldn't make it an option in your contract. Come at me if you completely disagree, but I'm just trying to protect the industry as a whole here, especially in a contractual purpose. And I always like to give you guys options. So if you do that later on, then just use a raw file purchase agreement, and that will supersede, this specific sentence in your contract, and they're going to pay for the raws anyway. And then, of course, they need to know that the final gallery of edited JPEG images is going to contain a mixture of probably color images and black and white images. Then you're going to explain how additional edits will occur. So your post-processing is probably going to involve contrast, lighting, and color corrections according to your artistic style. And that would coordinate with your artistic style clause. So our contract always cross-references clauses so that they pertain to one another. And so this would say, according to photographer's artistic style clause as indicated in, say, section 10. And then any additional editing requests will be charged X amount, either per image or per hour by the photographer, depending on how you go about it. And if the additional edits are requested by a client, that those edited images won't be released to them until they have paid for the invoice for the additional edits. So then you want to explain what type of additional edits you do. So probably cosmetic edits, like the inherent qualities of a person. So that's, removing facial hair, blemishes, wrinkles, changing, parts of the body, changing hair color, changing, shape or makeup on a face, removing or changing kind of accessories, shoes, glasses, those types of things. And then additional coloring edits, just basic ones like adding in sky, maybe you're using AI here, or changing out clouds. Maybe you have an overcast day and you need to change out what the sea color looks like because there's no reflection on the water. And so the water looks gray, wink, wink. Also, any type of saturation changes or slightly changing color tones, but of course, still in adherence with your artistic style and the style that they booked you for. And then, of course, you want a timeline on this. And then finally, you want to set a timeline for this. So they need to request additional edits within a certain amount of time of receiving their gallery. They can't come back a year later and then change course and ask you to do additional edits. You might be able to do it, but I would charge way more, and that's outside the scope of your contract. The only caveat here that I wanted to note is I know some wedding photographers do allow like a certain amount of images to be edited post sending the final gallery complimentary, but set boundaries surrounding that. So maybe the client can request, say, up to 10 images to receive one round of additional complimentary edits by you as the photographer after seeing their delivered images. But then you explain any additional editing requests beyond that will be charged X amount per hour. So this clause has always been in our photography contracts. We very, very slightly modified it the past couple of weeks just to make sure it is absolutely perfect. So if you have a wedding photography contract, an elopement photography contract from us, or a destination wedding photography contract from us, you will get the updates. That is a part of your purchase when you make the purchase with us. But for anyone else that doesn't have a TLP contract, just make sure that your image processing, retouching, and edits clause is really, really sound and concrete, so that your clients don't try to poke holes in it or try to ask you for a bazillion things post-production after you've already performed under the contract. Next clause is poses and selection of delivered images. This kind of aligns with the previous one, but it kind of has to do with no pose or photo can be guaranteed, right? Just because of the unique nature of wedding days and unforeseen circumstances. So if the clients were to give you a list, it'll be used for more, creative purposes, organizational purposes. And of course, you will try to the best of your ability to get all requested photos that the clients ask of you, but you just can't guarantee it. And that needs to be in your contract because you don't want them to come back and then ask for a refund because you didn't get that one photo and it was completely out of your control because that person was nowhere to be found during family, photo portions of a wedding. If you're a wedding photographer, you know what I'm talking about here. Then you want to explain really how your culling process works, that you as the photographer have the sole discretion to release and edit only the images that are deemed professional and of quality within your standards, and that constitutes all the images that will be made available to the clients. If your clients want to purchase and see all of the raw photos later down the road, you could offer that, but at a pretty high fee. Okay, next is delivery of images in online galleries. So this is all set expectations with your clients here. Always, always, always in a photography contract, put when you will deliver final images to clients. If I am a client and that is not in a photography contract, I'm not going to book with them because I want to know when I can expect my final gallery to be delivered to me. And give yourself a buffer here so that, of course, you're over delivering. I say, 12 or 16 weeks is probably max after the event date that a wedding photography client should be receiving their final images. If you do things differently, you do you, but this is pretty industry standard and what clients are looking for. I think 3 months is a really good buffer where you can still over deliver and get it to them even within 2 months or 2.5 months, and they're going to be really happy and pleasantly surprised. And then if you massively over deliver and you get it to them in 3 to 4 weeks or even 2 weeks after, you are basically amazing to them. So that is the first portion of this clause. And then it also kind of explains how many images that they can expect. So I like to suggest that you set kind of a minimum number for your clients, again, to have very clear expectations. So say if you have 8 hours of coverage, maybe you're going to ballpark 400 images for your clients. But you will always shoot 800 to 1,000, or at least cull 800 to 1,000 images. That's massively over delivering. But you have performed according to your contract, according to your client's expectations. The surprise and delight comes in, of course, with customer service. But again, foundational language in your contract is important. And if you learn anything from me going through each and every clause of a wedding photography contract here, know that a wedding photography contract needs to be two-sided. Of course, you are going to have more rights and responsibilities as the business owner that's drafting this contract. It's your contract after all. But a client wants to open this, or clients want to open this, and know that they have rights under this contract as well. Two-sided contracts are interpreted better. They are not always construed in favor of the clients because, it's just a one-sided contract. So try your best to make your contract, if you have an existing contract, more two-sided, where your clients feel really comfortable going through this and being like, okay, the photographer has now agreed to give me the images within 12 weeks. Amazing. Because then if they don't deliver in that time period without, some very reasonable excuse, and that an excuse I agree to, potentially, because you can always waive certain languages or provisions later on, but the clients are going to feel like, okay, they have to stick to that. And that makes me feel comfortable signing here. And then lastly, in this clause, you're going to explain kind of how the online gallery delivery process works. So can they download them all? Can they download them singly? Can they purchase professional prints directly through your online gallery site? How long will the link be available to the clients? Is it forever? Is it for 90 days, 6 months, 12 months? And then our contract, again, cross-references an archiving clause. So yes, the link will be available for that long, but then the clients are responsible for archiving pursuant to X clause, and that would be further down the contract. Next up, posting on social media. So this is where if clients or clients' friends and family, post a photo on social media, they either must or are encouraged to tag your business name. That's just dependent on your business policies. And this really, people are always asking me, like, why does this clause say client and client's agents or client's family and friends? Because your clients are now obligated and are bound to this contract if they send the professional photos to any third parties like family and friends and agents of them. They're still bound to the contract here, and they're going to be liable if something goes wrong. So a lot of times, are encouraged to tag is great because it's not like a must or a shall tag, and then it's a total breach of contract if they don't. But again, you do you. It's not something you're probably going to go after your clients for, but however you feel most comfortable, really encouraging your clients to give credit where credit is due on social media if they do post the photos there.
As a photographer, you're an artist and a business owner, and that is why it's so important that your contract covers both aspects of your job, your signature style and your client relationships. So if you're looking to solidify your existing photography contract and ensure clarity with your photography clients, I now have an exclusive photographer creative rights protection bundle that was designed just for you. This bundle includes 6 photography-specific clauses such as the image processing and retouching and edits clause, artistic style clause, delivery of images and online gallery clause, archiving clause, copyright clause, and poses and selection of delivered images clause. All 6 of these clauses are sold separately a la carte for $67 each. So the total value of this bundle is $402. But for a limited time, you can purchase all of them for only $167. Huge discount here. More than 58% off. So make sure to not miss out and get this bundle now if you are wanting to have any of these clauses that I just listed more robust in your existing photography contract. It's only available for a limited amount of time, and I will make sure to link this clause bundle in the description of our episode today.
Next is an artistic style clause. This is a big one that has come up a lot of controversy surrounding this post Sepia Gate. If you know what that drama is, if not, go listen to one of my previous episodes here this month. But an artistic style clause needs to be extremely clear around your client's responsibilities to spend a decent amount of time reviewing your work. And they have the reasonable expectation that the images you will deliver will be in a similar manner and style as indicated on your website, social media, and galleries that you've sent to them. That's on you to send that. If you don't have receipt of sending those things during the inquiry process, this clause is honestly no good for you. So again, it's a two-sided street here. The clients are taking on that responsibility and reasonable expectation, and that you're not going to edit beyond the scope of your specific style, but you have to still make sure that you're sending them the proper galleries and, things beyond just the best of the best on social media and your website. So send them full galleries. Please do so. And then your artistic style clause is going to say things along the lines of photography is a subjective art and that you have kind of unique vision, ever-evolving style and technique. But while editing styles could change from client to client based on weather, lighting, and other additional factors outside of your control, that it will be within the same style that you have listed everywhere and that your clients can expect to get from you. Of course, you would have the final say regarding kind of the aesthetic judgment and artistic quality of the images, and that dissatisfaction with the style and aesthetic judgment or artistic abilities are not valid reasons for terminating the agreement. or getting any type of refund. That needs to be in your artistic style clause. Take it from me, this is a really, really good, robust clause that we have in our photography contract. If you don't have that one, we have it a la carte. You can just get it and copy and paste that single updated clause in your contract right now. All right, I'm trying to move fast through this, but you can tell I'm really jazzed about this contract. It's one of my favorite contracts that I review basically every month. In an inclement weather clause. So this type of clause just needs to explain like what is your procedure with your clients if there's inclement weather, adverse weather conditions outside that really prevent you from performing services to the best of your ability. And that really is mainly for outdoor weddings and events. That's what needs to be in the inclement weather clause. It's pretty straightforward. Then a meals and breaks clause. I like to have this clause in wedding contracts because you're working long hours and you're on your feet. So I really want the clients to supply me with a free meal during the regularly scheduled time of dinner or, food that would occur at the event. And that you kind of prefer to eat, and this is specific to wedding photography. So if you're like a family and couples photographer or like a senior photographer or a newborn photographer, like this type of clause wouldn't be in your contract. But for weddings and events, you like to be present to be able to capture every single moment. And so kind of putting on the clients that no big moments are going to happen when food is being served so that you can eat. You're going to do it really quickly. And if they don't give you that you could be relieved for a little bit of time to go get a meal yourself and pay for it yourself. That's fine too. And then finally, just putting in your contract that you deserve a break every couple of hours to like go to the bathroom. That kind of thing is great in there as well. Just so your clients, I kid you not, I have seen this more times than I wish I would. But clients have been like, well, you didn't work for those 20 minutes when you were eating dinner and you kept taking bathroom breaks. Like imagine being pregnant or something and you're taking bathroom breaks and your clients aren't respectful of that. Just put it in your contract that that's allowed. And that of course, if you feel like you had to take off like way more time than you usually would, you could just tack on, 10, 15, 20 extra minutes to your coverage. But here it's saying in your contract that isn't necessary, that you're still going to shoot and you're still going to be there for like the 8 hours of coverage, but you can have breaks to eat and pee. Okay, model release clause. The clients need to grant you a model release as the photographer. That's what this clause is saying, that you have the right to use the images in kind of all forms, all manners, for advertising, trade, promotion, yada, yada, yada. There's a lot of legal language in here, but make sure you have a model release clause. Then make sure you have an archiving clause. So this is the clients accepting all responsibility for archiving and protecting their images, that you will probably keep copies of the edited JPEG images for a certain period of time, whether that's 6 months or a year or 2 years, but that you don't permanently archive all digital files. That's really important because even if you do, you don't want to be responsible for it because what if something happens? And then I always like to have like an archiving fee at the very bottom of this clause that if they can't find their images anymore and maybe they lose them on their external hard drive and those images are somehow still retrievable by you, it takes time for you to find them, to get the hard drive out, for you to upload to a gallery again. That time is valuable and you should be paid for that. So of course you're happy to do it, but just make sure in your contract that an archiving fee will apply. Next, a reproduction clause. So this is all about a personal photo release, which you as the photographer are granting to your clients and their agents, which would give them the right to use and reproduce the images for personal use only. It does not allow the images to be altered, sold, published, distributed to third parties, entered into contests, going to online blogs or publications without your express consent as the photographer. That's the reproduction clause. Next is a copyright clause. Also very important. It needs to be in every single photography contract that all photos taken by you. And right here, if you are the solo owner of your business, I like to always put your first and last name and then doing business as your LLC name or your sole proprietorship name or incorporation name, so that both are here, because you own the copyright usually, unless it's immediately assigned to your company. But I like to double dip here, make sure that you're protecting yourself on all ends. Photographer, legal first and last name, and your business. Own the digital images. It's your property, remains your property, and is protected under US copyright laws. Of course, there's additional legal language here, but I don't really need to go through that. This is a very legal heavy clause, so make sure that you have a solid photographer's copyright ownership clause and intellectual property clause in your photography contract, and that it was written by an attorney. Next, a venue and locations limitation clause. So we added this clause in and the permits clause, I would say within the past few years. And this is all because clients were getting upset with photographers for them not taking the responsibility to work with the location and, site management, and also pay for and acquire necessary permits if they were, photographing in locations that permits were required. So a venue and locations limitation just really says that you're limited to the rules and guidelines of the location and site management that the clients chose, and that they accept the results of that imposition on you as the photographer. And that if they need to moderate any of the guidelines, that's on the clients and not you. And then the permits clause is all about the client's responsibility for researching, acquiring, and paying for permits and licenses, or really any other permissions for any location where you will be performing services as a photographer. Of course, you will likely assist your clients with that. You're going to be working with them kind of during, the pre-wedding and event date to make sure that everything is, all squared away regarding this, but it's on your clients so that you don't get fined. If something were to happen, your clients would get fined. Next is a travel fees clause. This is one that I think a lot of photographers modify and change to their own business practices. But I'm just going to tell you base what is in our template clause, because I think it's the best suited to be applied across the board for multiple wedding photographers. A wedding photography contract from the Legal Paige website is one that's more for venue weddings, traditional weddings, where there is one location for the ceremony and potentially another location for the reception, or both of those locations are at the same place. Usually your package price would include any travel within a certain range, or say you have agreed to go to this location. Here's what I'm saying here. Your clients need to choose the location first, or at least a region where the location will occur, so that you agree to travel to that location either free of charge or for a small fee. And that needs to be outlined in your travel fee clause. And then if there's anything beyond that, then you would get paid for your additional travel. Remember, your time is valuable. You're decreasing your vehicle's value. And if you don't have travel fees or include them with your package rate, I really, really want you to modify that here for what is exactly included in your general travel fee. So usually businesses place, again, a limit on the maximum distance of travel in their base photography package. And then if you do it either as a flat fee, like if you're going beyond, say, 30 miles of, X zip code, maybe it's $100 for that, for 30 miles. Or you're doing, the IRS standard mileage rate of 0.67, which it is right now, but you can always go to the IRS website and they have those listed for every single year. And then, of course, additional, if they move the location and say now it's 2 hours away, they still want you to go and work, and they still want to be under contract with you, that if they decide to change that, that would occur like additional fees for transportation, lodging, per diems maybe. All of that needs to be explained in your travel fee clause. Next is a client's responsibility to secure insurance clause. This came about with COVID. So we have probably had this in our contracts since right away in 2020 when a lot of different clauses were revamped, depending on every client having issue with every single clause in a photography contract. Most of them were pretty sound. But this one is all about day of wedding or event insurance, and that clients are responsible for acquiring any and all travel, flight, or wedding event insurance. So they can protect themselves for unforeseen events or extreme weather or things really beyond all of the parties' control. That is, client's responsibility and gives them that information in your contract itself. Next is a communication clause. I love this clause because you need to set boundaries with your clients and expectations from the beginning. I feel like with photographers, your communication is so good at the beginning because you're trying to book them. But guess what? You're setting that expectation with your client. And then if you don't tell them what they can expect moving forward, they're going to rely on how you did it during the booking and inquiry process when you were probably bending over backwards to try to get them booked as a client, or at least doing a bit more of communication than you normally do because you're working with multiple clients at the same time. So modify a communication clause, of course, to your own business practices, but it needs to explain what your office hours are, what your primary source of communication is. Usually that's email, so that you're not getting texted and DM'd from your clients at all hours of the day and that you feel obligated to respond. You don't. You can always say here, please direct this to my email, so on and so forth. And then that you as the photographer will respond within a certain period of time, unless as otherwise, noted by the photographer, like if you're on holiday or vacation or something like that. I wouldn't put that in the contract, but you could just say something like, unless otherwise notified by photographer. So again, you are also obligated to keep in communication with your clients, but this communication clause really serves a dual purpose. Your clients want you to be responding to them, and then you want your clients to be responding to you because there's things that need to get done and questions that need to be answered. So hopefully your clients are also responding to you within a certain period of time as well. So again, two-way street clause here. I really like this clause. And then I never suggest that you give out your phone number to your clients until a certain period of time before the wedding or event date, but then still do so for, emergent issues that may need to be resolved via text or phone call prior to the wedding or event date. Next is a confirmation of day of photography schedule. So usually, and again, if you don't care what the clients are doing and you're more of a documentary style photographer, you would probably change this clause to say that. But for a lot of wedding photographers, you're working with your clients beforehand and planning out, okay, this is kind of the order of events of your wedding day and what I can expect from my photography schedule. And solidifying when that will occur, usually it's really close to the wedding date. They're not going to know exactly what their day is sort of generally going to look like until 1 week prior. And then if anything were to change, like when they wanted you to start the hours of coverage and end the hours of coverage, that should be usually within 24 to 48 hours of your actual start time. And of course, make sure that is very, very clearly outlined in this specific clause. Next is a harassment clause. Unfortunately, as photographers, there's just things that are beyond your control that could occur, whether that is inappropriate, threatening, hostile, offensive behavior from clients or clients' agents, either throughout the contractual period or in person at the event. And this is not only sexual advances, but it could be verbal conduct, physical conduct. It could be harassment related to race, sex, creed, color, marital status, sexual orientation, family status, disability. All of that constitutes harassment. And you as a service provider are not required to stay under contract with someone and work with someone that you are not comfortable working with and feel has harassed you. So this clause would allow you to terminate services and or leave the event in a harassment situation without a two-strike rule. I don't like two-strike rules because I don't want to suscept people to have to be harassed twice in order to leave and terminate. So if you have to terminate, of course, you're going to notify the clients and that you would retain all monies paid as liquidated damages as a result of this harassment situation, and that they as clients will relieve and hold you harmless as a result of incomplete services. Again, base foundation here in your contract. If a situation like this would occur, you are probably going to handle it very, very differently than your other colleagues. And you may adapt this where you're not going to actually leave the event. Maybe you're going to distance yourself, or maybe your second shooter is going to take over for the rest of the event, so on and so forth. But I like to have very, very concrete language in regards to harassment in a photography contract, because unfortunately, I do think it happens to the majority of photographers at some point in their career. And then the last clause, that's more of the middle clauses surrounding your business practices, and then we're going to get into general provisions, is a safe working environment clause. I like this clause and was one that we also added in, sometime around 2020, is a lot of things occur with your clients kind of wanting you to be exposed to unsafe working conditions. And I don't know why, but with photography and service providers in general, they want you to do a lot. And you're a business and you're a person, and you shouldn't be in those type of, positions or situations. So, don't let your clients, carry weapons or firearms without your knowledge, be exposed to severe illness, or really request you to do anything illegal or unsafe. There are instances where, like, if they didn't get a permit in X location and you're, being asked to go to a spot to take a photograph, that's one, unsafe, but two, illegal. This clause would allow you to not do that and for you to rely back on your contract. It's just a way easier discussion for your clients day of, and for them to just, you to be kind, but also professional and stand up for yourself. Of course, this also would apply to like wildfires. We had that a lot in, I think, 2020 as well. But over the past, 5 to 10 years, where there's unhealthy air quality or kind of similar occurrences, where you wouldn't feel comfortable photographing an X location, and that in your sole discretion, you could kind of veto something from your clients. And then hopefully all parties can kind of come to a mutual resolution of where to perform services that would be an alternate safe location to do so. Okay, we got through all of the major photography business practices clauses. I'm going to go quickly through general provisions and what they are for and why you need them in your contract. So starting with an indemnification clause. So indemnification clauses address the duty to compensate and defend for losses incurred. And our clauses involve the clients indemnifying you as a photographer for losses incurred under third-party claims. I have blogs on indemnification clauses. I think I have other podcasts on indemnification clauses. For whatever reason, if your client has any legal background or family in the legal world, they are always going to take issue with an indemnification clause. And I just find it funny. It's like they're flexing their arm for whatever reason. Whether an indemnity clause will be enforced really does depend on the governing state law in your home state. But most always you can have indemnification clauses for third-party claims. A lot of times parties can't indemnify themselves against, like actual negligent acts of the other party, but a client can certainly indemnify you from third parties coming after you for whatever reason. Like, they should be taking on that responsibility for third party liabilities, expenses, losses, those types of things, damages that could occur to third parties. That is an indemnification clause in a nutshell. I'm going to stop there. Go listen to all of my other resources on indemnification clauses, and I'll be sure to put it in the description of this podcast as well, so it's easy for you to find. Next, a maximum damages clause. This really just explains that the remedy for any actions or claims by the clients for any breach of contract or negligence on your part is limited to a refund, and that the maximum amount cannot exceed the cost of the contract. So the package price, that's it. They can't also get additional damages on top of that. And then that coincides with the next clause, which is a limitation of liability clause. So in all photography contracts, you as a photographer should not be liable for any consequential, indirect, incidental, special, exemplary, punitive, or enhanced damages. This is a very, very legal heavy paragraph and a limitation of liability clause. You're going to see that across really all service provider contracts, but particularly in a photography contract and in a wedding contract, elopement contract, destination contract, you want to have a little bit more of a robust limitation of liability clause regarding things that are beyond your control. So if media has been lost, stolen, unusable because of, equipment malfunction or defect or damage, anything outside of your control, they would relieve and hold you harmless as the photographer and not impose additional liability. So you're limiting your liability under this clause. And that any liability that your clients may, try to claim you for would be limited to kind of a percentage of the total amount of images that you did deliver, like a proration kind of language in here. Next is compromise coverage due to causes beyond your control, right? Wedding guests, smartphones or cameras or flash in photos, lateness of spouses, family members, wedding parties, vendor obstruction, right? Content creators, wedding planners, videographers, caterers in shots. Your clients can't hold you, liable for that. That they're just there. You're just capturing the day as it occurs. This is especially true for people in the aisle at the ceremony. You can't control that. That's on your clients to control. You're going to just capture it as it unfolded. Any weather conditions, schedule complications, just anything rendering of decorations, if they're upset with the florist and then how you photographed that. I mean, that's not on you. You're just photographing it as the florals were obstructed for their event. And then you're going to also more double down here on the venue and location limitation clause, and you're going to limit your liability again for any restrictions of the venue, location, or officiants. Next up, a force majeure clause. So a force majeure clause was one that everyone had laser beam focused on in 2020. It should apply to each party to the agreement. And these clauses specify the events which enable either party to declare what's called a quote unquote force majeure event, and then how a party would notify the other party about the occurrence and consequences after a force majeure event has occurred in relation to non-performance. Remember, a force majeure clause is all about excusing performance and delaying performance and ensuring that non-performance due to a force majeure event does not constitute a breach of contract. A force majeure clause is not a get out of jail free card for clients. It's not like, hey, this occurred, so I'm going to terminate the agreement. That is not what a force majeure clause is. A force majeure clause says, if there's failure or delay in fulfilling or performing anything from either party under this agreement, you're also giving this bone to your clients. Like if they had an earthquake or hurricane or, explosion or, another pandemic or natural disaster, or there's, some government order or law or terrorist threats. I mean, the list goes on and on here. You want to expressly delineate what is quote unquote a force majeure event in an act of God. But it has to be something beyond, it's above superior control, right? That's what force majeure means. And so it has to be beyond the control of the parties and it's delaying fulfilling or performance under the contract. It just means that the impacted party will use diligent efforts to end the non-performance or delay here, and that they will then pick up their obligations as soon as reasonably practical after the removal of that force majeure event or the end of that force majeure event. And if it doesn't occur, say, within 30 days, there's all kinds of like notification and timing in this clause. So say the force majeure event was impacting your client. They need to notify you that there's a force majeure event impacting them. If they don't notify you, then you don't know about it, then they still need to perform under the contract. So first course of action, they notify you. And this could also be vice versa, right? Whomever is the impacted party. Then they need to try to resolve performance within a certain period of time. I like to think 14 days, 30 days maximum, 60 days, maybe, I would say 30 days. Is a really good, reasonable amount of time to allow people to pick back up performance. They have to use diligent efforts to try to pick back up performance or pay you, so on and so forth. If they don't, then either party could terminate the agreement due to the force majeure event. But termination doesn't mean a refund. Termination means a transfer of fees paid to a new date for you to perform still under the contract at another date. Force majeure is all about delay of performance and non-performance. It's not a way for clients to claim something and terminate. That is a voluntary cancellation by client, and that goes up to the cancellation by client clause. Okay, I said I was going to go quickly through these. I'm still very passionate even about general provisions because they are legal heavy. These are near the bottom of your contract. They should be in all of your photography contracts. But they're really important, and I think people just gloss over these. And also, it's just good for you to know as a photographer what these clauses mean, why they're in your contract, why I put them in your contract, and how they may come up in XYZ situation. So next is a cancellation of services by photographer clause. Sometimes we call this a cancellation of services by company, but I've designated photographers as quote unquote photographer with a capital P throughout the contract. So that is what we are keeping with. This is, you can say no to servicing a client due to certain situations that are beyond your control that would come out, right? Due to certain situations beyond your control that would come up, right? So injury, illness, death of a family member, pregnancy, military orders, religious obligations, other personal emergencies that you can't control. If you have to cancel, you're going to give notice to your clients. And this is like a 1, 2, 3, 4 step here. It's really, really important that you outline these procedures to your clients. They're going to feel more comfortable and feel like you're a more competent professional because you've thought of this and how this is going to go down. You're going to notify your clients. Of course, you're going to attempt to find someone else to take your place, but you can't just say you're going to find someone else. They have to agree. So it has to be within mutual agreement of all of the parties. Do your due diligence and try to find another competent professional, but your clients have to agree to that because they've booked you. And if they don't want to continue on with this other person and maybe they're an associate for you and they agree to moving forward in that respect, they don't have to. But that needs to be in your contract that you will do that. And then if it's not available or if the clients don't agree to that transfer of obligations, that you will then issue a refund or credit based on a reasonably accurate percentage of the services you have already rendered. Very important language here. So they can't get a full refund, especially if you've already performed services. I do always suggest if you are in a situation of having to cancel and you can give a full refund, putting the clients back in the position that they were prior to contracting is your best legal option here for not having further unnecessary recourse from your clients. But if you can show and your clients can agree to, yes, you've performed these services, you've delivered this, maybe it was a complimentary engagement session that you put under your package, which I never suggest you put in a wedding photography contract. If you haven't noticed, I haven't said this at all here because I don't like them being in a wedding photography contract because it's quote unquote complimentary. So they could get a refund for that if you don't perform the main portion of your services. Okay, I digress. But have this language, again, base foundational language in your contract. And then based on facts and circumstances of you having to cancel as the service provider, you do what you think is best practice here and to avoid any other legal recourse from your clients or claims from your clients. And then step 4 is the clients will excuse you of any further performance under the contract. And then clients are excused from any payment obligations under the agreement. Very last miscellaneous provisions is sales tax clause. The clients are responsible for paying sales or use tax. In addition, to the package price, that'll be on their invoice. An entire agreement clause that this contract is a binding agreement. It incorporates the entire understanding of the parties and everything is within the 4 corners of this agreement. It would supersede any other written or oral agreements between the parties. So your clients can't down the line say, well, during our initial call, you said XYZ. Maybe you were saying that was an option, but they didn't take that option and now it's not in your contract. So this is a really important clause in that respect. So your clients are agreeing to be bound within the four corners of this agreement. And if you guys need to change anything or modification, amendments, addendums, then you would need everyone to sign such a thing, and it would need to be attached to this original agreement. Attached in electronic form as well. It usually just references this original agreement here. Next, a venue and jurisdiction clause. So this is all about where disputes will occur and what state laws apply. Very important if you're a destination photographer, if you're an elopement photographer and you're going out of state for weddings, and especially even if you are in state but your clients are from a different state, you have to define where the venue will be for construing legal matters. And usually that's in your state, that's most convenient. And then the jurisdictional laws that will apply. Again, your state laws. And then the venue would be your local county and state, or your local jurisdiction and state. Just so your clients are subjecting themselves to where you live as a photographer. This is one of those clauses that is not two-sided. It's very much one-sided. They are hiring you as a business, and you reserve the right to choose where a dispute should occur that's most convenient for you. You can negotiate this clause, but I just don't recommend it. I think you should have this be a little bit more cited towards you as the professional photographer here and the business that they are hiring to do this service for their business. Then an arbitration clause. These are really awesome because it says that the parties are bound to kind of an alternative dispute resolution, and it saves lots of money and time through going to small claims court or actual state court for litigation purposes, and that the parties would need to arbitrate the matter first. Arbitration is binding. Sometimes mediation isn't binding. So this clause just states that the parties agree to try to resolve all disputes with arbitration first before then they go to, federal or state court. Then a severability and no waiver clause. This clause basically says that if there's any portion of the agreement that's found to be unenforceable or invalid under your state laws, this is really important for template contracts, and especially if you don't get yours reviewed by an attorney and checked off. Every single attorney for basically every single contract that ever exists, even beyond photography and the service industry itself, always has a severability clause. So if one clause or a specific sentence of a clause is basically crossed out, that the remainder of the contract remains valid and enforceable. And then also no waiver is similar to this, where if a client waives a provision or you waive a provision as the service provider, that it doesn't constitute a waiver of the entire agreement or any other portion of the agreement. I like those two together because they go hand in hand. So we call it a severability and no waiver clause. You may see at the bottom of your contract that there's a severability clause and then a no waiver clause. Finally, I'm trying to get through this as quickly as I can. A transfer clause, so that the agreement can't be transferred by either party to another third party without consent of all parties. A headings clause, which basically says, the way the lawyer drafted this agreement was just for convenience purposes, and the headings were supposed to be like easy to read and easy to understand, in layperson terms, what that clause is about generally, but that the headings aren't supposed to be construed as part of this agreement or against any party. A notice provision, which explains, okay, to give proper notice from one party to the other, usually it's via email, and then you enter your email and your client's email or emails. And then finally, an electronic signature clause. This needs to be right above the signature lines. And it basically just says, the agreement could be executed in counterparts. So executed by each client separately via their email or smartphone, or desktop. And then you would execute as well as the photographer and, separately. So this is all about electronic document signing. No longer are we signing, together with actual printed paper and we're all in one room. That just really doesn't happen anymore, except maybe for real estate transactions at a title company. But for all intents and purposes, I have never seen in my lifetime. I don't even know if back in the day, 10, 13, 15 years ago, when I was kind of getting my photography business started, I did print my contracts and send them to my clients. They signed and then sent them back. So the contract was still executed in counterparts, but it wasn't a facsimile signature. So it wasn't an electronic signature. Both of those are covered in this clause. But I don't ever think I actually sat down at a table and signed a contract with my clients. I'd be happy to like jump on a phone call with them back in the day and like go through the contract. But yeah, just for convenience purposes, obviously everyone's signing things online. You need an electronic signature clause, and it includes two things: the counterparts portion and then the facsimile signature portion, so that, an electronic signature makes the signing by that client or party to the contract valid. And then lastly, signature lines. Make sure you say each party has read, understands, and agrees to the terms and conditions of the above agreement. Client 1 signs, prints names, dates, client 2 signs, and then once they both sign a wedding photography contract, make sure they have joint and several liability there. Get both clients to sign a wedding photography contract, always, 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 and then you sign as the photographer. That's it. That was a really long episode, but I think hopefully it was a really good episode for you, and you learned a lot as a wedding photographer going through these clauses. And if you ever have questions from your clients, like, hey, why is this clause in my contract? And how can I convey this to my clients? Like, why this is in here? They want to negotiate this clause, or they want to do, X modifications to this clause. Your contract is your contract. Yes, you can negotiate. I don't suggest that you negotiate too much. You don't want to give too much control to your clients. This is your contract. It should protect your business. It should be somewhat two-sided, but it is your contract. Always remember that. And if they have questions about something and you need to explain it to them via email or jump on a phone call, this is a great episode for you to come back to and listen to that specific portion of this episode where you're like, okay, Paige was talking about, the cancellation by client clause at, this particular part of the episode. And I need to go listen to that so that I can accurately understand and educate myself and have enough knowledge that I am prepared for that phone call with my clients prior to signing. The more professional you are, the more educated you are, the more knowledge that you have about your contracts, the easier it is for your clients to be able to sign, because you are going to be able to convey to them why you have this contract to begin with. And they're going to see that. They're going to either try to see right through you, or you're going to hold your ground and you're going to be able, in layperson terms, like I just did, hopefully to have a conversation with them and make them feel more at ease and comfortable with this very large document that they're signing and a lot of money that they're paying to have you service probably one of the most important days of their entire life. So there you have it. If you have any additional questions, you guys can always reach out in the Legal Paige community on Facebook. Myself and my legal team are there. We get questions each and every day about various portions of the contract that I just talked about. And remember, a lot of these clauses are a la carte at thelegalpage.com. So you can purchase clauses separately and add them to your existing contract. Or if you're like, oh my gosh, Paige just went through so much and I have a lot missing in my contract, please just go get the full length contract template, press the easy button, have the done for you solution, get it up and running, within 30 to 60 minutes, use the contract time and time again. All future updates to the wedding photography contract you will get emailed to you. I will explain which clauses we have updated and why. And so you can make sure that you are kind of DIYing a contract audit yourself every 6 months, every 12 months, and that you're staying up to date on the legal language that needs to be included in it. Thanks so much. Catch you in the next episode.
Thank you so much for tuning in to today's show. Be sure to visit thelegalpage.com for contract templates, blogs, YouTube videos, and additional legal resources. If you haven't already, head over to iTunes and leave me a review and rating. It truly means so much to me to hear your feedback and inspires me to continue creating podcast content. Also, I want to personally invite you to my free Facebook group at tlpfacebook.com, where you will get access to me, my legal team, and thousands of other entrepreneurs in there for unlimited business and legal Q&A. Until next time, my friend.